Okay, well, hello and welcome everybody. My name is Brian West. I'm a partner here at McCarthy Tétrault in the Calgary office. Today's topic is the construction law roundup for 2021. However, as much as it is a look backward at the year that was, it is also a projection forward at how trends that have been developing over the last year are expected to roll out in the upcoming year, 2022, new changes that we see coming, how case law is going to impact your business going forward. Today we have just an excellent group of presenters. Everyone today here is from a specialized Calgary construction subgroup in our office, and we're going to be speaking to developments in construction, contracting, procurement, project administration, disputes. This is affecting projects both large and small. The audience here today consists of those who own projects, those who are constructing projects, those who are financing projects, administrating, experts, anyone from changing the light bulbs to putting up a large tower or highway. So that being said, it's going to be fairly broad in terms of the structure that we're going to speak to, but we are happy to get into specifics. As to some of the housekeeping here, we're going to be asking for questions to be put into the chat function as we're going through the presentation. However, when we wrap up and at the end, we will take the lock off the mute button. And so if you want to ask your question directly, feel free to do that, noting that this session is being videotaped for further review, or if you want to take a look at it, or if you want to share it with some of your colleagues later, you're happy to do that. So before we get to our presenters, I thought that I might just contextualize some of the topics that we'll be speaking about today and put into your head maybe some of the key points that you should be taking away. If you listen to nothing else during this presentation and you want to walk away with some knowledge, then perhaps those key points will stick with you. So the three main topics, or the three buckets that we'll be speaking about today: new construction market legislation. We'll be speaking about the Alberta market primarily, but the impacts that we're speaking about really have ramifications across the country. So prompt payment legislation is in place, or is coming in place just about everywhere. And if you've listened in on one of these presentations from us before, you've probably heard us talk about prompt payment, and we probably told you about a year ago, it's coming in June, or it's coming in July, and then it never came. And so maybe you have some questions for us about why it never came, but why we think it's coming this year. The next major category that we'll be speaking about is COVID. It's 2022 and all things are still COVID delay, COVID related claims, COVID supply issues. So we'll be speaking to the impact of COVID upon construction projects, both as it currently stands, as it did in 2021, and what we expect for 2022. And tied into that is a third theme we're not going to spend a lot of time on today, so I thought that I might spend a little bit of time on it, which is good faith comes to Canada. Good faith comes to contracts. This concept of the good faith performance of contracts has spread out to all types of contracts in Canada, thanks to the Supreme Court and the evolution of contract law that is emanating from that august authority. And is now being implemented by courts of appeal and by Court of Queen's Bench and by all legal decision makers across Canada. What does it mean for your business? Well, if I was to distill it down, this is what it generally means. It means in the performance of your contract obligations, parties are not permitted to lie to each other. They're not really permitted to purposefully mislead each other in the performance of the contract. And they need to be accurate about when they're communicating with the other side about contract performance metrics. And so how does that sort of play out? What do I mean by that? Well, in the construction industry, some of the examples that have come out have been like this. Does your contract have an automatic renewal clause? Well, you can't mislead the other party to saying that you're going to trigger that, or you're going to honor that, or you're going to keep them on. Even though that might not be a specific lie, if you're leading them down the garden path and they're expending money, when it's time for the renewal of that contract term, that can be considered a breach of the performance, of the duty of the performance of good faith. You have a contract where it says that you need to pay all your sub-trades before you get paid. You can't say that you paid all your sub-trades when you really haven't. That would be a lie. That can lead to a breach of the contract, and the penalties can be quite severe, even if it's a that might be considered a white lie in the industry, or it might have in the past. No longer, and certainly it can be a fundamental breach. So, ultimately, what do you need to do in the performance of your contract? You need to act reasonably. It doesn't mean that you can't look out for your own interests. It can't mean that you can't negotiate toughly. It can't mean that you can't put clauses into that contract that favor one party over another. It doesn't mean any of that sort of stuff. But it means when taking a look at the contract, you can't lie, you can't mislead, and you should act reasonably. Okay, so those are my initial comments. I think we'll get right into it, and I'll start sharing my screen. So I go from the introducing this to being the administrator of the PowerPoint, and I will be jumping in here or there to perhaps add some commentary or ask some additional questions to some of our presenters. Now, Andrew, nod your head if you can see the PowerPoint up on the screen. Jordan nodded his head, so that's good enough. So these are the topics here. I've done my introduction. Andrew's up first with our 2021 Alberta legislation update, and Andrew West is an associate here in the Calgary office. And Andrew, take it away.
Thanks very much, Brian, and good morning, good afternoon, everybody, depending where you're tuning in from. Recognizing this is the 2021 legislation update, we're actually going to jump back to October of 2020 first. This is when the provincial government introduced Bill 37. Many of you will likely be familiar with this one at this point. This is, the first big stab from the government of Alberta of bringing in changes to the lien system here in the province. Our group did a deep dive on this legislation back in the summer, and so a link to that presentation, I believe, will be circulated in the chat box below. A couple of high-level changes, though, from Bill 37. One is the introduction of the prompt payment regime, and the second is the introduction of the adjudication system. Jocelyn will be touching a little bit on prompt payment, and Jordan later on will be talking about adjudication and what that system looks like. But the overall goal of Bill 37 was to reduce or remove barriers to keeping funds flowing down through the chain or the construction pyramid, looking at sort of increased and delayed payment timelines that were plaguing the industry. So there was those two high-level changes that were structural, but there's also a number of other detailed little changes, such as the increases to the lien period depending on the type of work, the introduction of a new type of work and improvement in the form of concrete work, as well as some changes to access to information rights, etc. So that's Bill 37, and then we jump ahead to Bill 62. This is tabled by the government in April of last year. And what this one does is, ironically provide some clarity and amendments to Bill 37, which itself had not been enacted yet. Helpful clarity in particular was provided with respect to what does the new Prompt Payment Construction Lien Act apply to. There were a lot of questions from stakeholders in industry about, sort of the interplay with public works or about P3 projects. So Bill 62 makes it clear that the new act will not apply to public works projects where there's agreements or financing with the Crown or provincial corporations and things like that. So making a very clear distinction between, the new lien system, prompt payment, adjudication, et cetera, applying to sort of private contractual relationships, but not with the Crown. The government has said and has stated and published on their websites that under the Public Works Act, they intend to follow the letter or the spirit of the new Prompt Payment Construction Lien Act. But like I said, no firm commitment or legal, authority or requirement under that new act to follow these new rules. Bill 62 also provided some very helpful clarification around the adjudication process. This is, as I said, one of the larger changes that the system will be undergoing. Again, questions from industry and stakeholders about how this process will work, and in particular, the nature of the decisions that come out of an adjudication. And so Bill 62, provides some clarity on this point, in particular to whether decisions are final and binding or interim and binding. And so Bill 37, as it was written, stipulated final and binding decisions. And this is in contrast, for example, to the Construction Act in Ontario, which was introduced and enacted a couple of years ago, where decisions are interim binding. So the Made in Alberta approach is how the government coined it here, I think led to a bit of confusion. And so Bill 62 makes it clear, and you'll see it there on the slide, that adjudication decisions are binding, except in the case of a court order, a party applying for a judicial review, the parties entering into a written agreement to appoint an arbitrator under the Arbitration Act. Note that it's the Arbitration Act only as of now, and not the International Arbitration Act. Or then finally, if the parties, generally agree and enter a written agreement that resolves the dispute otherwise. So a number of carve-outs, a number of parties, or a number of ways for one or both parties to get around an adjudication decision if they don't agree with it, which is interesting to note. And as I said, Jordan will touch on the adjudication process a little bit more later on today. So where are we now? Those are the first two bills, bringing in this new system here in Alberta. The best way to describe it is a bit of a holding pattern. Brian alluded to it at the beginning. We were here last year and a few months ago telling many of you to look forward to this new system and to expect it on Canada Day of last year. That hasn't come to fruition, I think in part due to delays attendant with the response to the pandemic and uncertainty arising from that on the part of the government. And I think also, as I said, a lot of uncertainty from both Bills 37 and 62 in terms of what the system will look like and what it means for your business. So the government, endeavored to go back to the drawing board, as it were, increasing, further stakeholder engagement and seeking input. And so as it stands now, Service Alberta on their website and to stakeholders has made it known that they intend to table the regulations next month in February and to bring the new act into force finally in July of this year. Some questions around, procedurally, you would expect that Bills 37 and 62 will come into force at the same time for a clean transition, given that 62 amends 37. But that will be interesting to see how that plays out. And an important note is it's a quick transition. It's a hard deadline whenever the new act does come into force. So unlike in Ontario, for example, where their new system provided for the parent or the overarching master contract to be the determining factor with some distinctions for subcontracts in terms of the transition periods. Here in Alberta, when the new act comes into force, assuming that is July 1st, 2022, any contract entered into after that date will be under the new act. Any contract previously entered into will continue to be under the old act. The next slide here just gives you a picture of kind of where things stand. So notwithstanding the delays with the implementation here in Alberta, we actually remain, sort of ahead of the pack in some ways. Ontario, has been a few years ahead of everybody. If assuming the new system and act comes into force here in the coming months, we will be ahead of, for example, British Columbia and several other provinces. You'll see on the slide there that Saskatchewan's appears to be next up and slated to come into force in March. And then beyond that, there's a few other provinces and jurisdictions that are in limbo. For example, Nova Scotia has had their statute receive royal assent more than 2 years ago, and likewise for the federal prompt payment regime, which will be important for any companies who have involvement across jurisdictions or who are working in federally regulated industries. So that's where things currently stand. But as Brian said at the outset, big change is sort of coming across the board, in the near to midterm future. And then there's one last piece we wanted to flag here for statutory or legislative updates, and that is the introduction and the coming into force of the Infrastructure Accountability Act. So this piece of legislation came into force last month on December 8th. It provides a new capital projects governance framework, and I put the air quotes on there because the criteria that this new act outlines for the government's purposes are the same criteria that they have been referring to, I think, for quite some time in terms of judging, funding proposals and sort of capital funding strategies. Nonetheless, it makes it very clear in the new act that these are the 6 criteria that the government and the responsible minister must consider when evaluating capital planning submissions. The second one there in particular is interesting in terms of alignment with government priorities and strategies. It also requires, for example, the responsible minister to consider the full life cycle cost of projects. So somewhat vague criteria, and also not helped by the fact that the new act does not require the relevant minister or party to publish its findings or scoring or rating based on these criteria. So the government is required to look at them, and presumably behind the scenes will be applying values or weights to these different categories for a respective proposal, but that information is not required to be published. So something to kind of bear in mind. The other big change that this new statute brings in is the introduction of a 20-year strategic capital plan from the government. Previously, these plans have been on a much shorter term basis. Going forward, there will be a 20-year plan published by the government. The first one was published last month on December 16th. It's about a 150-page, very detailed document. This document is required to be updated every 4 years. And so you see on the slide there, just kind of one little screen capture that I grabbed. As I said, it's a very detailed document, and I encourage everyone, to look into it to the extent you're involved with, public projects. This gives you an overview of the current replacement value of the government's infrastructure assets of last year. So you'll see, a huge, and not surprising amount of it is for transportation in terms of roads and bridges, things like that. And the next biggest category would be, health and education type buildings and assets. So it gives you a good picture of sort of where things currently stand. The report notes that over the last period of time, the government has been averaging $7 billion a year of public funding for such infrastructure projects. So this kind of slide, I think, gives you just an idea of where things stand and where things might be going in the near to midterm future. Seniors and social housing, for example, appears to be a bit of a laggard in that regard. So that's where things stand in terms of statutory and legislative updates here in the province. So I'm going to pass it over to Jocelyn now, who's going to speak about financing the project.
Thanks, Andrew. And that was exactly 10 minutes. So you are bang on time. However, I was going to put you just a little bit over time by asking you this one question, which is for the business leaders that are on the video chat today, or on the video presentation today, if there's a key takeaway or key takeaways from this legislation update, what do you think they would be?
Yeah, so I think the biggest things are, and we touched on this in our presentation back in the summer, which again, the link will be in the chat box. There are a number of detailed changes in terms of, tracking spending and in terms of maintaining proper invoices. So Jocelyn will touch on that a little bit, but I think, reviewing your internal processes, making sure your precedents and your template contracts and appendices and schedules are in accordance with the new requirements, in particular the timing of those of the new statutes, I think will be very important. And then, as I said, in terms of maybe guiding your business or thinking in terms of mid to long-term strategy, I encourage everybody to look at this new 20-year strategic plan. It's quite detailed. It has projections on population growth, changes in sector, education changes, in the demographics of the province. So a very interesting document, and I think they actually have put forward something that's very helpful here for stakeholders.
Great, thanks very much, Andrew. So now over to Jocelyn Turnbull, who's going to talk about the financing aspects, touching upon, and I think growing from Andrew's presentation, particularly with respect to the legislative changes and how those are going to impact financing. Jocelyn's a senior associate in the litigation department in Calgary, and she is an expert in this area. Jocelyn, take it away.
Thanks, Brian. Well, so first off, I'm going to start with a bit of a quick reminder. Andrew has highlighted that the Prompt Payment and Construction Lien Act is going to mean big changes. And one of those big changes is in the way that you finance projects and the way money flows, the way contractors are paid. The new legislation, as you'll see from the diagram on the screen, dictates very specific timelines for invoicing and payment for construction projects. So the timelines for payments under the new legislation are what I would consider to be tight. There is a 28-day window. So from the time a proper invoice, and we can talk about what that means, is received by the owner, there's 28 days to the date of payment. And there are 14 days for that owner to dispute any amounts in the invoice. Failure to dispute within the 14 days means you're paying on day 28. And that timeline will naturally create a bit of a crunch in receiving construction draws, the financing that's required to get all those payments out the door. 28 days is a very tight timeline. When the legislation was being discussed and proposed, it was sort of floated around that on average, people are being paid 60, 90 days. So this going from 90 days or 120 days to 28 days is going to be a bit of a drastic change in terms of the invoicing and payment structure. To make matters a bit more difficult, under the new legislation, owners will not be allowed to make payment conditional on a third party approving the invoicing from contractors. So that is often a clause that we see inserted in contracts, and it's specifically dealt with in the Act. And so the legislation is very clear, 28 days from that proper invoice, you must pay. It's also very clear about what should be included in that proper invoice. And the parties to whatever construction contract can agree to add information to that proper invoice, but you can't agree to take information away. So there is a set sort of minimum amount of information that must be included. And provided that your contract does not stipulate anything additional, that is all the information you're going to get before you need to write that check. So, if you have obligations to meet under various financing arrangements, we're encouraging everyone to consider whether or not you can legitimately, without running offside of the legislation, obviously, make your life a bit easier by demanding specific information from contractors be part of that proper invoice. So under the contract, if you can add information that makes your life a little easier, makes it a little bit easier to get those financing hurdles cleared, then we're encouraging everyone to think about the structure of your agreements and to start adding and implementing some of those changes. Again, the new legislation, I think, is going to be a bit of an exercise in organization, in that you're now going to have to be even more organized than you were previously in order to be, checking over all those invoices, making sure you have all the information you need, clearing various draws, getting, all your payments in a row. It's going to become, as Brian always says, you can't just keep these invoices in a shoebox. It's not going to work anymore. You're going to have to be organized. You're going to have a system and a flow. So I think putting up this very clear and very scary 28-day timeline is helpful as a picture of just how little time you're going to have once those invoices start rolling. I also wanted to remind everyone that the Prompt Payment and Construction Lien Act continues to apply to improvements or lienable work. It does not cover things like maintenance. So there was a 2021 case, Young Energy Serve and LR Processing, you'll see there on the screen. And it examined the language in the current Alberta Builders Lien Act and determined that only work done in respect of an improvement on land would be something that is lienable. And the new legislation, the Prompt Payment and Construction Lien Act, is going to maintain that same language. And so what projects previously were considered maintenance services kind of work will not fall under this legislation. If it's not lienable, then doesn't apply. So I encourage everyone to be very careful about the way in which the contracts are structured, what the work is for, and how the language, even in the contract, suggests that the work might be maintenance work as opposed to actual construction, new construction, or improvements. So that language will not be changing, just to be clear. And so if you have any questions or concerns about that, please feel free to reach out and we can give you a bit of a rundown, but I'm sure everyone on this is well versed in that already. The final note that I wanted to make is about just an insolvency reminder for everyone. This case, I know it's a 2020 decision and we're supposed to be giving you a review of 2021, but I feel like the waves of this decision sort of rippled throughout 2021, and it's the Supreme Court of Canada's decision in Chandos and Deloitte. And that case was, general contractor Chandos had entered into a construction contract with a subcontractor, Capital Steel, and the value of the contract was roughly 1.4 million, so relatively large. And the construction contract contained a clause that outlined what would happen if the subcontractor were to cease operations as a result of insolvency or bankruptcy. And these clauses, I know, are common, and the court came down and said, ultimately, when Capital Steel went bankrupt, the trustees turned to Chandos and said, you need to pay Capital Steel their final invoices. There's outstanding money and we're due and owed that money. And Chandos refused and said, no, we have this contract, and a clause in the contract clearly says that if there's bankruptcy or insolvency, we are to receive an inconvenience fee. And that inconvenience fee would more than cover the amount that is currently due and owing to Capital Steel. So we're going to set the amounts off against each other, and we don't owe you anything. We're not going to pay Capital Steel or their trustee any amounts of money. And ultimately, the court came down and said the clause in the construction agreement is invalid. It runs offside of the anti-deprivation rule, which is a common law rule essentially designed to ensure that people aren't writing agreements in order to get around bankruptcy and insolvency legislation, or to benefit themselves above other creditors who would have to find themselves waiting in line with their hands out at the end of the insolvency proceedings. And so, long story short, the court has come down and said, not appropriate. These inconvenience fees or this language around what penalties will be paid if the company declares bankruptcy or becomes insolvent during the term of the contract, all of that runs offside of the anti-deprivation rules, and so therefore not appropriate. Now, there's a strong dissent by Cote. For any lawyers, you will know there always is strong dissent by Cote, but that is the law currently. And the court made one obiter comment about possible workarounds, and it was interesting. They weren't sure. They weren't going to actually throw out this as a firm suggestion, but there was hints that inserting clauses for insurance, so that insurance would be taken out over the project, or potentially that parties could insist on security being put up. So in this, in the instance of an insolvent subcontractor that had posted security, the security could then be collected on without that impacting other creditors. So simply suggestions by the court, not firm recommendations by any stretch, but something to think about in terms of what your contract currently looks like, and perhaps how you could better protect yourselves. So Again, 2020 decision, but I feel like 2021, there was a lot of focus on how we revamp and redraft contracts that include these kinds of inconvenience fees and penalties for any kind of bankruptcy or insolvency of subcontractors and contractors for that matter. So that's it from me, Bryan.
Wonderful. Thank you very much, Jocelyn. And also excellent timing. Excellent timing. Moving on to papering the project. Okay, so a properly constructed contract, that's where it all begins. As a litigator, of course, I love improperly constructed contracts because that's what causes, that's what brings in the most amount of work. But if you want to avoid seeing me, at least for that reason, then you can listen to this next presentation. This is going to be done by Erinn Wilson. She is a student in the Calgary office. She is also instrumental in keeping updated and live Construction Law Canada, our specialized website. What a great website about construction law run by this team, which you can visit if you want to get up-to-date information about the law in this area. Erinn, take it away.
All right. Thanks, Bryan, and good afternoon, everyone. So when papering a project, one of the important things we always want to consider is what are the terms of the contract. So as I'm sure a lot of you are familiar with, commercial agreements usually will attempt to incorporate or make reference to separate documents in attempts to have the other documents included in that main contract. So we call this incorporating by reference. Now, incorporating by reference, it can take lots of forms. So either you can try and incorporate entire agreements into that main contract, or sometimes you're simply trying to incorporate specific terms, parts, or specifications. And this can happen not just at the beginning when the contract is formed, but it can also happen, occur throughout the length of the project. So for instance, additional terms and conditions, they could be incorporated by reference in a change order. So I'm going to first set out some key takeaways that you'll want to remember when you either see these or if you're going to put these in your contract. And then I am going to talk about some specifics about it and give an example from a recent Manitoba decision. And then I'll circle back to these key takeaways and give some examples of how you can kind of implement them. So starting off by saying, incorporating by reference is a technique that you can use, but sometimes it can lead to disputes. It can make the contract a little messy, as Bryan was saying, and then gives us a job, I guess, essentially. So to reduce the potential for the disputes or the messiness, our three kind of suggestions would be to be specific about what terms are being incorporated. Ensure the terms of the other document don't contradict with the main document, and then make sure that the terms of the other documents are brought to the attentions of all the parties. So those are kind of our key takeaways. Now, the benefit of incorporating by reference, there's two kind of main benefits. Bryan wants to go to our next slide. So the two main benefits being time saving and convenience. So time saving, instead of having to redraft those other documents into the main contract, you can simply just reference them. And then convenience, we see this a lot because the subcontractor is performing part of the work that's specified in the prime contract. So it just kind of makes sense to reference the prime contract instead of rewriting it. Now, there are some major drawbacks of using this kind of technique. As I was saying, that if you're incorporating documents, sometimes they could be unsuited either in whole or in part to the contract that you're trying to incorporate them into. So if there are inconsistencies between all these documents, the courts then is going to have to determine what terms are part of the contract and what parts aren't. The tests that the courts use to determine what terms are included and what aren't is just the three basic elements that they use to determine whether or not there's a binding contract. All of these three elements you see up on the slide there essentially boil down to a meeting of the minds. So, all the all the parties to the contract have to know the terms, and they have to intend to be bound by those terms. So one of the recent examples of a potential drawback is kind of this cautionary tale from Manitoba Court of Queen's Bench, their decision in Razor Contracting Services Ltd and Evoqua Water. I'm going to give a quick overview of this decision because it is that cautionary tale, and especially in this electronic age when our contracts are increasingly negotiated, transmitted, and executed electronically. So in Razor, there's the bid documents included a subcontract agreement with specific terms and conditions. But instead of executing the subcontract agreement, the contractor, Evoqua, just issued a purchase agreement that attempted to incorporate by reference the contractor's terms and conditions that were contained on their website. And one of those terms on the website was an arbitration clause stating that any disputes would be resolved by way of arbitration. The court had to determine whether or not that arbitration clause contained on the website, whether or not it was sufficiently incorporated into the contract to bind the parties to that arbitration clause. So the court ultimately concluded that the arbitration clause contained on the website was not incorporated into the contract between the parties. The court found that there was no meeting of the minds on the arbitration clause due to the following facts. If Brian, you want to go to that next slide, I'll put the facts up there so it's easy to follow. So in this case, Razor's president, which was the subcontractor, he gave evidence that he attempted to access the website, but was unsuccessful in doing so, and then didn't take any other steps because the original bid documents contemplated executing that subcontract agreement, which obviously never happened. And then Evoqua didn't take any steps to draw those terms and conditions on the website to Razor's attention. And the last fact that the court looked at was that the terms and conditions on the website were different than the terms and conditions contained in the subcontract attached to the bid documents. So this decision is kind of like the perfect storm of things that didn't go Evoqua's way when they try to incorporate by reference the terms and conditions on their website into that purchase order. So yeah, all in all, the court said, no, those terms aren't included. And that's our kind of cautionary tale. So certainly back to our key takeaways, you can do this, you can incorporate by reference, but we would suggest using these kind of following suggestions or tips when you're either drafting your contracts or reviewing them. So one, be specific about what the terms are being incorporated. One easy way to do this is just to attach the other documents as schedules to that main contract. And if you don't want to attach them and say you're only incorporating part of the other document, just be specific what part or what terms you're pulling from that other document into that main contract. Now, our second suggestion would be to ensure the terms of the other documents don't contradict with the main contract. So you can do this by inserting a hierarchy of documents clause. This would stipulate that if there's any conflict between the main contract and any of the other documents, that the main contract would govern. And then, if that doesn't do it, then Schedule A, or the document is Schedule A, and then if that doesn't do it, then the document is Schedule B. So it kind of just sets out that hierarchy of how conflicts are going to be determined. So the last suggestion would be ensure the terms of the documents are brought to the attention of all the parties. One way of doing this would be putting a clause in the main contract that stipulates that the parties have read those other documents or have gone to that website and that they understand them. For instance, if you wanted to incorporate a website, you could say something like, I understand the terms and conditions that govern this contract are located on a website and I have reviewed them. Another way is to use electronic tools to ensure that the parties have agreed to the terms. So, we're all pretty familiar with those little checkbox or acceptance little tools And there's also other things like DocuSign that have similar tools that you could add just to give evidence that all the parties have read or seen the terms at least. Now, lastly, we're going to give special caution to arbitration clauses and websites. So in a couple of recent decisions from last year, arbitration clauses were kind of the big topic, and there's a presumption that arbitration clauses located in the other documents would not be incorporated. Essentially, there's a higher standard if you want to incorporate arbitration clause into that main contract. So if you wish to do this, be sure to use specific language that the arbitration clause is being incorporated from the other document into the main contract. Simply saying, we governed by terms and conditions like they did in Razor isn't good enough. You're going to have to be specific that that actual arbitration clause is going to be incorporated. The other thing you want to make sure you do is that have evidence that the arbitration clause was brought to the attention of the parties. So this is what all went wrong in the Razor case, is that those terms and conditions weren't brought to attention to the parties. Our other special caution would be for websites. So you want to make sure that you have evidence that the parties have interacted through the use of the website, or that they've taken steps to bring the existence of the website to the attention of the parties. You could also, and then one other thing you would want to make sure that you have evidence that the terms and conditions or whatever document you're trying to incorporate was actually posted on the website at the time the contract was entered into. So those are kind of two special cases that you want to have some caution in when you're incorporating by reference, or if you're reviewing a contract that's attempting to do those things. Those are all my thoughts on that topic.
Wonderful. Thank you so much, Erin. In our last presentation here, we're going to give it over to Jordan Bierkos. Jordan's going to talk about disputes in the project. Jordan's a senior associate in the McCarthy Tétrault Calgary office. I always wonder when we apply senior. I think it's senior. You're definitely senior, Jordan, and just absolutely works this topic over day in, day out in his daily practice, and knows his stuff. So Jordan, take it away.
Thanks, Brian. Maybe the moniker applies to the extent of your receding hairline. So
I think that's right. I think
we'll leave that particular topic for another day. And today I'm just going to talk about disputes in the project, and specifically the procedural aspect of disputes. And you might be thinking, procedure, Jordan, are you really going to talk to me for 10 minutes about procedure? Gouge my eyes out right now. And I say, wait and hold on, because remember, the treasure often lies at the darkest part of the forest. So stay with me, brave out the discussion about procedure in the resolution of disputes. And what you'll see here right off the bat is the key takeaways. If you take away nothing else from my discussion, it's that you should be reviewing your contracts to ensure that they have a dispute resolution process, number one. And if they do have a dispute resolution process, ensure that it's workable in the present dispute environment. And the second takeaway is, again, the theme that's run through this presentation so far, which is that the Prompt Payment and Construction Lien Act is coming into force. So we are assured by our benevolent political leaders. They tell us it's coming into force for sure this time in July of this year. So be sure that your processes and your systems are ready, because the statutory adjudication that comes along with it, the dispute resolution procedure, is going to play out within a period of days or weeks. So you have to be ready to launch a full-scale assault or defense within that time frame. So moving along to the substance of this part of the talk, as Brian said, it's no surprise that COVID continues to be the main overarching theme. And yes, there are disputes that relate to the substantive impacts of COVID on a construction project. I mean, there are delay claims. There are supply chain issues, as I'm sure many of you are well aware of in your personal lives and in your professional lives. But if there's one takeaway, I mean, I think it would be this. It's the fact that parties, particularly in the post-COVID world, for contracts entered into after the onset of the pandemic, I think parties have done a fairly good job of dealing with those issues and these tensions substantively in the contracts. Surely these issues are being addressed and spoken to specifically. And I think generally what is the case is that we're not seeing much of the substantive disputes related to COVID, more so as we are seeing actual disputes about how that dispute is going to be resolved. Because all of the old disputes that were continue to be, so just run-of-the-mill change orders, work valuation, shoddy work, the like, the daily grind of construction disputes continues to exist. But the problem is that's taking place within the same environment that courts are dealing with the pandemic and trying to respond to that. And particularly in Alberta, anytime you're before the Court of Queen's Bench, they like to remind you that we are short of justice. And we have been for some time. So the court system in Alberta was operating generally beyond its capacity, was overburdened. And then you've added in the pandemic to that, which caused a shutdown and adjournment of a lot of matters. And then you had a lot of other COVID-related disputes in all industries. So you had more litigation, everything that was pushed back. And what that resulted in is you now have a court system that is shaking under the weight of the disputes that are before it. What this practically means for the disputed environment is if you don't have alternate mechanisms for getting your disputes resolved, you're going into a system that is well overburdened. And so actually trying to get your matter before a decision maker who has the time and attention to look and make a considered determination at the underlying dispute is exceedingly difficult. And that's particularly problematic in the construction industry, as I'm sure everyone is well aware of, that disputes in construction tend to take on a life of their own and tend to snowball. That what starts off as one small dispute can quickly impact other aspects of the project and snowball out of control and disrupt an entire project. So the need in the construction industry is particularly high for having an early identification of disputes, containing those disputes, and then resolving those disputes as soon as possible to get clarity to actually get a project done without having that dispute spiral out of control. So that's the disputed environment. If we go over to the next slide, Brian West, aka Vanna White, we will look at, okay, what are we going to do about this, Jordan? You're telling me that the disputed environment is locked up with disputes. What do we do? The underlying objective, as I said, is to obtain that early certainty. And the best way to do that is through your contract. Having a look at in what way are we going to identify and resolve disputes early on. And the first measure is to be sure that you have some mechanism in the contract to actually identify these disputes and to prevent them. And dispute prevention clauses take various forms, but at a very minimum, you will want to look to, does my contractual counterparty have an obligation to notify me where there's an issue or where there's a potential issue? Notice requirements are a big piece of the dispute prevention or containment puzzle. Do I have notification requirements? And are there requirements to meet once a notice is sent? In addition to specific meeting requirements, so where the parties can actually identify a dispute and sit down and try and resolve it and get at least a consensus on how they're going to address it. In response to a notice, there can be provisions for requiring project meetings or issues to be addressed at the project meeting and have regular obligations to meet. The other dispute prevention measure that can be used is the early appointment of a project mediator. So the CCDC style of contracts do contemplate the appointment of a project mediator at an early stage, meaning within 10 days of the start of the contract. You may want to consider bringing that in, or where things start to get into disputed territory, to get a mediator on board, because the chances of being able to consensually agree to a mediator or to an independent party, that's somebody who can sit in that capacity decrease with the elevation of the dispute. So trying to get somebody, a neutral party appointed after the dispute has already reared its head and started to evolve can be very challenging. So the early appointment of an independent party, consultant, what have you, to sit in that mediating role can be a benefit. Beyond dispute prevention measures, there is this issue of adjudication. You've heard that adjudication is coming as a mandate in the statute. Before even getting to that, you can put an adjudication clause within your contractual documents. And this is an aspect, that I mentioned in the CCDC style of contracts. Many P3 type contracts have clauses in this capacity as well, but contractual adjudication, where you're appointing somebody to be the de facto decision maker early on. And in the CCDC contracts, that party is the consultant. Now, this surprises some consultants, even consultants who are retained regularly in relation to projects that use a CCDC contract. They are in a de facto adjudicator position. So reliance on that is something that's underutilized in those types of contracts, where you can get a decision on something from the consultant early on in the project. That's a big benefit to the parties, to at least get some certainty. The decision of the consultant might be overturned later, but in the meantime and in the interim, that decision is binding on the parties. So what ability do you have for some party to be able to make a decision that's binding on the contractual parties? And the last thing that I'll say with respect to the contractual measures that you can take, if Bryan will go back one slide, it's the arbitration provisions. Arbitration was and has been for some time the preferred method of dispute resolution in the construction industry. No time is it more valuable than now, with the courts the way that they are. Arbitration provisions are going to be worth their weight in gold. One thing to be mindful of for those of you using the CCDC contracts is the fact that the default terms in those contracts don't make arbitration mandatory. If you haven't invoked it within a fairly short timeline, you may want to revise those to make arbitration the mandatory result in all cases. But perhaps the most important aspect is reliance on an institution to appoint the arbitrator, where the counterparty does not want to be dragged into arbitration for whatever reason. If they want to delay the determination of a dispute, the easiest thing for them to do is to simply not agree to appoint an arbitrator. And if you don't have a specific agreement, the court is the first stop there. So it can take months just to get your arbitrator appointed if you don't have some independent means of doing that. So the lowest hanging fruit, or the easiest way to give some teeth to an arbitration provision is to appoint an institution. So ADREC, ICDR, JAMS are probably the most common in Canada. Institutions who will appoint an arbitrator. So the parties need only write to that institution, and even if the other party, if the respondent disagrees, those institutions can still appoint an arbitrator, and you can at least get the matter off the ground. And lastly, I just put in here the use of commercial courts. The Crosslinks decision out of the Ontario Superior Court, it was probably the best example of the parties being able to rely on the commercial courts to get a determination of a matter where there was some urgency to get a decision, and it concerned the extension of the substantial completion date on a contract. The court had held in that instance that the failure to get determination on that issue would lead to other impacts or results for the project, namely insolvency, liquidated damages, termination of the contract, and what have you. That was considered a sufficient urgent circumstance to warrant use of the commercial courts, which is much more robustly staffed, and you can get before that court much quicker. So if you are stuck with a contract that doesn't have one of these dispute adjudication mechanisms, you can rely on the commercial courts. In terms of adjudication under the statute, as Andrew alluded to, this is coming, and this will make it mandatory if another party invokes adjudication and it's under a qualifying contract that is one entered into after the act came into force. You cannot contract out of this, so you will have to go to adjudication. In other jurisdictions, what we're seeing is that this availability of a quick and expedient way to get a decision, meaning in Ontario, that's the closest analog that we have. There are much fewer disputes being instigated than you would have anticipated. So in Ontario, where this is available now, you see from last year, there were only 50 claims launched. And you have to imagine that there were probably many more lawsuits than that filed in the years previous when this right was not available. So what you can take from this, would be a few things. Well, one of them would be the fact that it appears to be greasing the wheels, that the ability for a party to go and get a binding decision early on can sort out a lot of the claims that were just didn't have any sort of merit to begin with, that parties are realizing that where there's some teeth to a dispute resolution mechanism, they simply don't bother with it. But you see, from all of last year, there were 50 disputes. Of those 50 disputes in Ontario, 34 went to a decision. And from these two slides, we saw there were over $8.7 million of claims advanced. The amount of claims actually awarded under the adjudications were less than $1 million cumulatively. So the average amount that's being paid out is only $26,000. In the first year of its enactment, most of the disputes fell within the residential sector. But what we're seeing here in this table from last year in Ontario is that there were actually more transportation and infrastructure disputes that were decided in adjudication than there were residential disputes. So it's being used in all sectors. It is seeming to weed out a lot of the disputes. And so far, claimants don't appear to be faring all that well if they're getting roughly 10% of the claimed amounts. So that's kind of a sneak peek of what you might expect to come in the latter part of 2022 once we have adjudication available in the province. We see just on this last slide as a final point that the sorts of things that are being adjudicated here relate to your standard construction disputes. The valuation of materials and the payment due under a contract are the most disputed items through adjudication. So with that, I will leave it there. I know that we're running up against the hour, so if you need to go, you need to go, but I thank you for your attention to this point. And if you have any questions, we're happy to hang around and answer them.
Thanks very much, Jordan. So as the title of the presentation today alluded, this is a roundup. We covered a lot of topics today. We're happy to answer any questions that might come from the audience now. Otherwise, certainly anyone that's on this video chat today, any of these presenters are happy to answer those questions. You can contact us through email, you can phone us, whatever you like. All of us have done deep dives on all of these subjects and have read the new act multiple times, have written articles about it, have written books about it. And so if you have any questions, we're all happy to take some time to do that deep dive as well. But if you have any specific questions now, we're happy to answer them. This is where we prepared. Jordan was going to ask me some questions, and we were just going to vamp for 5 minutes. But we are right at the hour here, so if there are no specific questions, then we're happy to let everybody go. I'll give it 10 more awkward seconds. No. Okay. Well, we must have done a very comprehensive job then. Okay, well, thank you very much. Thank you to everyone who tuned in today. Thank you to each of the presenters. And stay tuned for the next one. We'll probably, the next topic we'll cover, we'll probably zero in on one of these topics and explore them in more depth. And we hope to see you there. Thanks very much.